I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. The chair of the Arizona Republican Party, MAGA extremist Kelli Ward, lost her emergency application to the Ninth Circuit Court of Appeals, where she tried to get the Ninth Circuit Court of Appeals to enjoin or stop the January 6th committee from getting her T-Mobile phone records. The January 6th committee had prevailed in the district court action in the district court in Arizona. Kelli Ward sought that the district court give a temporary injunction preventing her records from being turned over to the January 6th committee pending appeal. The district court denied that relief. She then sought the relief from the Ninth Circuit Court of Appeals. She sought that they issue an injunction pending the full appeal, and the Ninth Circuit has just denied Kelli Ward's relief. And in pretty strong language, they denied the relief. It was actually a very interesting panel of Ninth Circuit judges. You had one Clinton appointee, one Trump appointee, and one George W. Bush appointee on the Ninth Circuit panel. And it was actually a 2-1 decision denying Kelli Ward's motion for injunctive relief. And it was actually the Trump appointee and the Clinton appointee who made the ruling denying, and the George W. Bush appointee made was in the dissent. And so Silverman is a Clinton appointee, Miller, Trump appointee, Akuta is a George W. Bush appointee. Those were the circuit court judges, and Akuta was writing in the dissent. And what this opinion basically said is that the First Amendment does protect the freedom of associations and political organizations to conduct certain business in anonymity. For example, their membership rolls and private communications have a heightened protection, what's called in the law an exacting scrutiny. And to overcome an exacting scrutiny, you would have to show this compelling government interest, and you'd have to show that the subpoena is very narrowly tailored. And here, after the analysis that was conducted by the Ninth Circuit, they said that the exacting scrutiny standard does not apply here to Kelli Ward, because what we're really talking about with this subpoena from the January 6th committee has nothing to do with Kelli Ward's political associations or affiliations, despite Kelli Ward trying to make it seem like, oh, this is just my business as the chair of the Arizona Republican Party. What the Ninth Circuit pointed out is what the January 6th committee is looking for is your conduct in connection with the insurrection, which should have nothing to do with the Arizona Republican Party. In addition, the only information that is being sought, because the only information that exists from these T-Mobile phone records is the metadata. So that's just like the phone numbers, the dates and times of the calls, and the duration of the calls is some of the information that the January 6th committee is seeking. And the Ninth Circuit Court of Appeals says there's really nothing there that should subject this to any exacting scrutiny standard, as though this was some legitimate political conduct. But the Ninth Circuit goes on even further, though, and says, even if we utilized the exacting scrutiny standard under the First Amendment, we would still have come out with the same result, that Kelli Ward needs to turn over these T-Mobile phone records to the January 6th committee. And here's the language that they use. They said, because there is no indication that the compelled disclosure in this case would deter protected association activity, the exacting scrutiny standard does not apply. But even if it did apply, the subpoena would satisfy it. It's substantially related to an important governmental interest in investigating the cause of the January 6th attack and protecting future elections from similar threats. Now, here's the very strong language that the Ninth Circuit used. Ward participated in a scheme to send spurious electoral votes to Congress, a scheme that the committee describes as a key part of the effort to overturn the election that culminated on January 6th. And so remember, Kelli Ward was intimately involved in the fake electoral scheme and having a fake electoral slate. And she was significantly involved in the January 6th insurrection. Regarding whether the subpoena is narrowly tailored, the court's analysis goes on to say the January 6th committee indeed tried to get this information directly from Kelli Ward without having to subpoena her phone records. Indeed, they called her in for testimony, but Kelli Ward pled the Fifth. It goes on to say when the committee sought to question her about those activities, she invoked the Fifth Amendment and refused to answer. Now, we've talked about here on the MeidasTouch network and in the videos that I've done that in a civil proceeding as opposed to a criminal proceeding, when you plead the Fifth, when you assert the Fifth Amendment right against self-incrimination, it is what's called an adverse inference, meaning a court or a jury can infer that the reason you are not answering the questions you are being asked when you assert the Fifth is that the answers would demonstrate that you are liable with what you are being accused of in the civil case. This is different than in a criminal case. In a criminal case, when you plead the Fifth or when you don't testify, the prosecution is not allowed to say to the jury, hey, let me explain to you why Kelli Ward is not testifying today. She's pleading the Fifth, and I want you to infer from that that she must be guilty. Absolutely can do that in a criminal case. In a civil case, you can do pretty much exactly what I just suggested regarding the statements that the individual who pleads the Fifth doesn't answer in a civil case. And so the January 6th committee, in seeking to compel these records, made it clear to the Ninth Circuit Court of Appeals, look, she pled the Fifth, and so this is what the Ninth Circuit says in response. In this civil proceeding, it is appropriate to draw adverse inferences from Kelli Ward's assertion of the Fifth Amendment privilege, namely that Ward's conduct during the period in question went beyond simple discussions with her political associates, and that those with whom she communicated might have information about her activities that she refused to provide. Having attempted less intrusive methods of asking Ward directly, the committee has a strong interest in pursuing its investigation by other means, and the subpoena is narrowly tailored mechanism for doing that. And then it goes on to say it's only seeking the dates from November 1, 2020 to January 31, 2020. So why did the Ninth Circuit, if it found that the exacting scrutiny standard does not apply to Kelli Ward and that the January 6th committee could get the records on that basis, why did they then do the analysis of the exacting scrutiny standard and say, even if this standard applied, we would find that the January 6th committee should get these records anyway? What do you think the answer is? The answer is that the Ninth Circuit realizes that to the extent Kelli Ward wants to file an appeal arguing that the Ninth Circuit applied the wrong standard, they want to protect their order regardless and say, we believe for these reasons the exacting scrutiny standard does not apply, but even if it did apply, we reach the same outcome. This way, Kelli Ward can't try to argue to the Supreme Court the Ninth Circuit applied the wrong standard here, and it needs to go back to the Ninth Circuit for further review. What this is somewhat similar to is you think about in the Lindsey Graham matter, what took place with the 11th Circuit Court of Appeals and the district court in Georgia there, where Lindsey Graham did not want to testify and is still trying to block testimony before the Fulton County special grand jury. And there, the issue that Lindsey Graham was asserting was speech and debate clause privilege under the Constitution, and saying that his conduct in basically threatening a state secretary of state to overturn results is legitimate conduct rather of a senator, legitimate legislative activity. And there, what the 11th Circuit had the district court do after Graham appealed at first was to conduct a very diligent and thorough appeal-proof analysis regarding the specific categories where speech and debate would not apply. Then when Lindsey Graham appealed again to the 11th Circuit found here are definitely the categories where the speech and debate would not apply. And then they built in the safeguard to say, in any event, if Lindsey Graham, while he's giving testimony before the Fulton County special grand jury, is asked questions where he thinks the speech and debate clause applies, he can still, on a case-by-case basis, make the objection and go to the district court. But you can't just not show up when you're being subpoenaed. They are also protecting their record there from conduct by Lindsey Graham, who they believe would try to appeal and find technicalities to get out of the ruling. So I wanted to give you that in mind, what the judges are doing and how they shape these orders to try to make these orders completely and finally binding to prevent litigants who are litigious from trying to wiggle out of the ruling. And then in terms of Kelli Ward, I'm just going to play this video for you very quickly, where Kelli Ward, this was from an Arizona Trump fascist rally that was held fairly recently, where she talks about being part of the Orange Mafia. Here, let's play this clip.
Hey, stand up if you're ultra MAGA! Ultra MAGA! Woo! Hey, I'm a proud member of the Orange Mafia!
That clip was from the same rally where you had Kari Lake, who's running for governor of Arizona as a MAGA extremist Republican, talked about all the parents in the crowd should speak to your children about the big dick energy of Donald Trump and Ron DeSantis. And she said, ask your children about BDE when you go home. Everyone needs to talk about big dick energy. You know, it's just such weird, bizarre, disgusting, and despicable behavior. Orange Mafia, BDE. I've said it here before on the MeidasTouch network, and I say it again. To me, these issues they should not be political. No matter what political party you are a part of, what you see from Kelli Ward in that video and what Kari Lake say, and this is going on across the country, that's not conservative. That's weird. It's disgusting. It's dangerous. And it's anti-American, frankly. It shouldn't be a political issue here. I always like to say that's what the stakes are in this election. It's what the stakes are for our country. And we need to be loud. We need to be out there voting and make sure we have adults in the room. Adults who take these issues seriously and aren't kind of these comical, parody-like, evil villains who truly want to harm the country and spread hate that we see with these MAGA extremist cultists. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button. We're on our way to 1 million subscribers. Thanks to your support. It's free to subscribe, so if you haven't subscribed yet, not sure what you're doing, please hit the subscribe now. Also, check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. I always get asked by you, how can you help grow this independent media platform? Our competitors, The big media, mainstream media, that both sides, that's annoying and dangerous and problematic, funded by billions of dollars every single day. We are fueled by democracy and powered by you. Zero outside investors. We do all of this with your support. So if you want to help, and I get asked by you all the time, Ben, I want to help. What can I do? That's what you can do. Please go to Patreon, patreon.com/MeidasTouch. There's a number of exclusive membership tiers there. Join one of those membership tiers. There's lots of exclusive content that you're going to love, behind the scenes footage, exclusive podcasts, but most importantly, it'll help grow this platform. Until next time, I'm Ben Meiselas.
This November is Rowvember. MeidasTouch just released its brand new collection of Rowvember t-shirts and pins to let the country know what's at stake this upcoming midterm election. Go to store.MeidasTouch.com to grab yours. That's store.MeidasTouch.com.